Okay. Oh, so easy. Can I just say, and I've got all this daylight coming in at home, and it looks really, yeah, awful. Awful. I want to let you in first and see if I can kick you out. So hurry up and get on. Okay, so which one of you am I going to hoof off to check that I can get rid of somebody? Catherine, you?
Oh, nice hair, Liz.
Ah. Oh, I like your hair down. You're on mute. You look very glam. You don't look as rough as you feel. Right, can you come back in though, please?
Yes.
Come on, Catherine.
Oh.
There we go.
Hello, everybody. It feels like ages since I've seen you.
So, Kathy, why did you have to kick someone out? I thought you were giving her.
So the reason I'm on is because we had that interloper last week coming on. So I've gone on as Caroline and renamed myself. I will stay mute, but I will hook people off if they've joined and they don't belong on here. So we don't have the problem we had last week.
Yeah,
and then
we were just practicing to see if Kathy could kick someone out, basically.
So I was just pretending she was the interloper and hoffling her off.
Okay.
Right, you ready?
Yes.
Hi, everyone. We'll just give it a few minutes just to see if there's anyone else joined before we get started. Is everyone all right today? It's very quiet.
Everyone must have a cold the same as me. Staying quiet.
Okay, so we are going to answer some questions for you today. But first of all, I just want to chat to you quickly about warnings, and Catherine also has a little topic to talk to you about before we move into questions. So if I'm explaining something you already understand, I'm really sorry, but we have had a lot of this come up in the last month or so. Warnings. When and how can you give an employee a warning? So one of the things we often hear recently is, oh, I've already given him a warning before. Okay, what kind of a warning? Oh, well, yeah, I gave it to him in writing. Okay, what process did you do? Well, I talked to him. Or I've given him a verbal warning already. So it's really important to understand that warnings is an outcome It's a formal outcome to a formal process. Warnings is not something that you can just dish out when you had to discuss something with an employee, which is probably what you mean when you say warnings. But calling it a warning is not the right thing to do. It's not the right way to do it, because if you call it a warning, that implies that it is a formal warning and there has been a formal process before that led to that outcome of a warning. So what do you do if you have a conversation with an employee about an issue? It's an informal conversation or even maybe a formal conversation, and you want to document that somehow, but you're not going to continue on with a full disciplinary process. What you do then is you can give something that we call an advisory note, but some people call it a record of conversation, for example, and that is where you would, in that document, you would summarize that you discussed this point, and that you are not going to do anything further about it at this time, but that you still want to make sure they understand that it wasn't acceptable behavior, and you'd hope you don't have to speak to them in the future. And if you have to speak to them in the future, then you might have to do that in a formal process. So if you feel like you want to give someone a verbal warning or just document a conversation you had with them, that's what you need. There is no such thing as a verbal warning anymore. That is just a conversation. So if you want to document that conversation, that's the piece of paper as such that you need. If you want to actually give a warning, like a written warning or a final warning, you have to follow a process. That process at least includes investigation and disciplinary. Sometimes it includes several investigations and a disciplinary before you can get to the outcome of a warning. It's also important to understand that you can't just give someone a final written warning when they've done something for the first time and it's a mistake, even if you think it's serious. So, and sometimes it is serious enough, which is why you need to talk to us about it. But we have seen a lot of this where someone says, oh, they made this mistake in their job, which is a reasonable task that they do every day. But they made a mistake this time. And maybe it's a mistake that's very serious and caused a big loss or put someone's life in danger, in which case it could lead to a final written warning or even dismissal. But if it is the first time they've done this, and the mistake is not that serious that it's cost you 10 grand or cost someone their life or nearly cost someone a hand, then you're probably not going to be able to give that person a final written warning or dismiss them, because it's a first offense and the punishment needs to fit the crime, I'm afraid. So keep that in mind. So next time you want to use the word warning, think about whether you have followed the process. You can't use the word warning if you haven't followed the process. That's a check for you. And if you want to give someone a verbal warning, that doesn't exist. Don't waste your time doing that. But you can give some sort of record of that conversation. And if you would like us to help you write that, just let us know. Is there questions about warnings before we go on to Catherine?
I was just going to comment on that as well, Nadia, that in terms of issuing a final written, one thing to consider is what you as an employer has done. When we're talking about mistakes and loss, we had a really interesting case recently where somebody had been scammed. So there was an employee who was stepping in for her colleague who was on holiday. It wasn't her role. She was helping out the business. As a result of that, she got scammed in an email to a loss of something like £7,000 to the business. the employer at the time wanted to basically dismiss her. She said, she's caused us this loss. It's gross misconduct. You know, it's negligence. And I said, yes.
No process. They don't want to do a process.
No, nothing. I said,
a very good example.
You know, you're totally right. This is negligence. I said, but is it negligence? Have you trained her? You know, does she know what to do if a scam email comes in? Does she know how to check a scam email? You've put her in to stand in for somebody who's on holiday, so she's not really that familiar with the role. So, you know, you've got to take, you know, it could happen to anyone in that circumstance, but the employee was adamant that, no, I want to dismiss this employee. She's caused us this loss. Yes, she did cause the loss, but there was a lot of mitigation around it. And you have to look in a scenario like that at what have you done as a business in terms of support and training. You can't dismiss somebody if you haven't supported them and trained them enough to know a process or a procedure. So that's something else to bear in mind when you're looking at something like a final written warning or dismissal. If at first, obviously the case seems really dramatic and you know there's been a financial loss to a business, you really need to kind of look at what you have in place yourselves and consider that as a mitigation.
Okay. Any more questions on warnings before I move to notice pay I'm going to talk about? No. Okay. So notice pay if a employee resigns. This has come up a couple of times recently and is quite unusual. So I will try and explain it to you, but if you're in that situation, just let us know and I can put it in writing. Sometimes it's a bit easier to digest in writing. So if an employee resigns and they give you notice, then you just pay and they work it, you just pay the notice as usual. Yeah. If they resign with immediate effect, and they make it clear they're resigning with immediate effect, you obviously don't need to pay their notice because they've told you I'm not working it. So you just pay for the time they worked, which might be just that day because they might walk out, for example. If they give notice, but you don't want them to work it, you have two options. Pile-on, we call it, pay in lieu of notice, which is where you make the payment in one lump sum and they're not required to work, or you can place them on gardening leave. So that's the easy bit. Where it becomes more complex, and a lot of people don't realise, is that if someone resigns and gives you notice, but they are off work, and by off work I mean is they are sick, there are actually some occasions whereby they are entitled to notice pay, because we would all just assume that if they're sick during their notice, they'll just carry on getting their sick pay until the day that they leave. But unfortunately, that is not the case. Now, so if you have someone who resigns and they're on sick leave and they're getting sick pay, you actually need to look in your contract on what your clauses were, the notice you would need to give them to terminate their contract. Yeah, rather than what they need to give you. So, I mean, I say it's unusual. It really is. If that notice period is the same as statutory notice or less than 1 week above statutory notice, they are actually entitled to 1 week's notice pay, and then the remainder of the notice is their sick pay. If your termination notice is more than a week more than statutory, then they just get paid sick pay for the duration of the notice period. So like I said, it's very complex and mind-boggling, and I can see the expressions there. So yes, I'm not expecting you to remember that, but if you have someone resign who's sick, by all means, just let us know and we can have a look which one applies. And like I say, so don't just assume they're going to get sick pay for the duration of that notice. There is instances, and actually I would say most common now, because most employers don't really give higher than a statutory notice to terminate, for example. So you could have to pay them 1 week's notice pay. Okay.
Another thing for notice to remember is that an employee can be on holiday and on notice at the same time, and you're only paying them once. So if they have a week's notice, so therefore you are paying them 5 days notice pay, but they have already requested holiday for that week and they are on holiday for those 5 days, they will use up their holiday while on notice, but you will still just pay them for 5 days, not for 10. You won't pay them for each of those. You'll just pay them once, but they are using up their holiday while on notice. So actually, if you ever do end up with that convenient situation, it is very convenient because you are paying once for two things.
On that as well, on garden leave, we've had a number of employees recently saying, oh yeah, we don't want him to work on notice. And a lot of people don't actually understand the difference between the garden leave and pay in lieu of notice. So one of the key things with garden leave is during that garden leave period, so their notice period, you would normally pay them monthly. That continues, but those benefits also continue. So they will accrue leave in that 2 months, in that 1 month, or that 3 month. So you've got to factor that into their final payment. They are available and they can't work during a garden leave period. So garden leave basically prohibits them getting any other employment. And it's normally useful in a case where you haven't got any kind of real issue with an employee, but you may need them to come back into the business. For example, if you're looking at systems or passwords, or they might have a document that nobody else has got. Pylon's more appropriate in a case where there's a dispute with an employee because it finalizes things then and there. You pay the pylon, but one point to note is that you need to pay that pylon ahead of the notice. You know, I've had clubs come and employees come and say, oh, well, we can pay it next month, or we can pay it in 3 weeks' time. No. Pylon is, by its name, lieu of notice. So you make that payment immediately. And that's kind of what tends to make the decider between whether an employee goes with garden leave or pylon, because it's the outlay of the initial finance. But yes, garden leave, they will accrue holiday, they have to be paid all the normal benefits. So just bear that in mind if you just want to kind of end the relationship completely with an employee. Garden leave is probably not the best way to do it.
There is another point about garden leave to remember, which we actually come across quite a lot, and we find it strange. Employees do not have the right to garden leave. And we do see this quite a bit, where someone says to us, well, the employee has said that they want garden leave, so I'm giving them garden leave. Really? Do you need them to have garden leave? Because that's how it works. Garden leave is a tool that an employer can choose to use or not use for the benefit of the business in that situation. It's not a right that an employee has. They can ask, they can say, can I possibly have garden leave? And you may say, sure, I'll consider it and get back to you. But that's about as much of an answer as they're going to get until you've decided. But you don't have to give them garden leave. They're not entitled to it. We have dealt with grievances, big ones, where people are putting a grievance in because they haven't been put on garden leave. Employees do not have the right to garden leave. Remember that it is a tool for you, not a right on the employee side. All right. Do we have any questions?
It's a lot to take in, sorry, of notice and garden leave. But any questions, just let us know.
I've got a question to Elizabeth on what she was saying about you pay straight away.
Oh, we've lost you, Mel. You've gone on mute. Oh, you're back. Sorry.
So having just let somebody go, I was under the impression, I think this is what we've always done, because they did ask about pay, where we just process it with our normal payroll at the end of the month if they've been given a week's notice. But from what you're saying is you don't do that. So
you should pay them out of cycle. Yeah, sorry, Matt. You should pay them out of the payroll cycle. So if you're terminating mid-month, you need to pay that lieu of notice ahead of the notice. The notice shouldn't pass and then you pay.
Right, okay, I didn't know that. And how does that, because I thought with payroll, now it's real-time reporting and all that nonsense, that you can't do anything out of sync anymore. So I don't know how that works. You just do it differently, do you? Or
the payment would be a manual payment. So you would make a manual payment. And then when the pay slip is run at the end of the month through your automated payroll, it'll be a in and out. If that makes sense. An
adjustment. Yeah.
Yeah. So that's how it works. So you will calculate it manually and do a manual payment. And then that will be, an adjustment on the actual pay slip.
Okay. Then adjust the pay. Okay, I'm just making a note. Okay, thank you.
We should say that outstanding holiday pay can be paid in the final pay. So if you have given someone notice and you're paying them in lieu of notice, or if you're paying someone in lieu of notice, you're letting them go in the middle of the month, you'll make the notice payment 2 or 3 or 4 or 5 days max sort of after that, so out of your payroll sync. But then at the end of the month, that pay slip will have their holiday as part of their final pay and the adjustment for the payment you've already made.
Just to clarify, when yeah, because you said this earlier about you get 2 for 1 or something. So even if somebody's only been with you 2 weeks, I guess, I don't know what 2 weeks equivalent of holiday is, but let's say it's 2 hours or something, that is still part of the notice pay. Did you say you don't pay the holiday on top of the notice pay?
No. The only time that you do that, it's a 2 for 1 is
if they've already,
if the employee is on holiday while they are on notice, and that will usually have to be pre-booked. So if an employee has holiday booked for the first week of December and they give you notice today and they have 2 weeks, 2.5 weeks or 3 weeks notice, then for that period that they have already booked holiday, they will go on holiday and you will pay them once for each of those days, although they are using notice and holiday at the same time. But if it's an employee who's, finishing in the middle of December, they don't have any holiday booked, they've got 5 days outstanding, you're going to pay them those 5 days. I mean, okay. there is a slight margin, and I don't want to confuse you guys, so keep this separate in your head. There is a slight margin where you might be able to use the rule of telling them to take holiday by giving them double the time notice. But that would mean that you would have few enough holiday days and enough notice days to be able to pull that off. That's a bit of a puzzle. I hope that helps, Mel.
I think the bottom line is if they've got accrued holiday and they haven't pre-booked it, Mel, then you need to pay it. And that's the bottom line. If they have a holiday already booked during the notice period, you would just pay that as normal and then the additional days as their notice. That's how it would be documented on your payroll slip. It's gone quiet.
Have we confused you all? I'm sorry.
Do we have
any questions?
You beat me to it, Nadia.
Sorry.
Got quite a quiet.
I've got an unrelated question to the topic, but I can wait until anyone's finished the related questions.
No, doesn't look like we've got any, Mel, so fire away.
Okay, so it's a working from home thing.
Okay.
So if somebody works from home because they're not well or not well enough to come in, they don't want to infect other people effectively, let's say that's the example. But how does it work in terms of then if somebody else who's, let's say, quite a bit more junior then says, well, I don't feel well, so I want to work at home. How do you make the working at home thing? Can you selectively choose who can and can't? How do you have to do it equally? How does it sort of work? Okay, so you treat one employee the exact same way that you would treat another, regardless of seniority, pay, anything. If you're letting somebody, for example, I'm at home today, I'm absolutely loaded with cold, but I don't want to infect anybody else. But I'm not sick. I'm well enough to work. So that's one big difference. If somebody is sick, Mel, they're sick. They're not working from home, and you shouldn't permit somebody to work from home, because I suppose it's a fine line. If you say to somebody, oh, go home and work if you're more comfortable at home. No, they're sick. They're sick. They cannot work. You kind of, what they could turn around then and say is that, oh, I wasn't feeling very well. I went home and my employer forced me to work just because I was at home. But if like the scenario that you've got where somebody's infected and they say, look, I don't want to give it to anybody else in the office, similar to COVID,
If you treat one employee that way, then you have to treat the other employee that way, regardless of seniority.
The only way you can differentiate, well, I knew I was going to trip on that, differentiate, is by looking at whether a job can be done from home.
Yeah.
So Liz's job can be done from home. But if we had someone who was an office cleaner, their job can't be done from home if they're feeling under the weather or have the boiler man or whatever, because they actually have to physically be there to do their job. And I know that this actually applies to your business. Some of your employees actually has to physically be there to do their job, whereas others may actually be able to access a system and work on a laptop from home. So that's the only way that you're going to be able to differentiate between who can and who can't.
So what about if somebody has a request because they live somewhere where there's massive roadworks and they're struggling with traffic, and they say, right, the roadworks are in place for 6 weeks. Am I able to work from home during whatever period, or, you know, because of difficulty getting into work? Is that a reasonable request? Is it something you should do or not do? I think
Catherine is really well suited to answering this question.
I feel their pain. No, all I was going to say is this the same employee that wouldn't go? We talk about the same one again.
Yeah.
No, Mel, they just need to leave earlier to get to work. But it really is
take public transport.
Yeah, there's no. Just no. Just no.
They accepted the job, Mel. Like I said to you, they accepted the job knowing the locations that you'd be working from. It's their obligation to get to work. Yes, as a reasonable employer, you can make reasonable adjustments for unexpected things, like the day when they had to divert so many miles out the way. But it's not your responsibility to get them to work. It's their responsibility. There are options around. You know, it's up to them, you know, and I think in this person, their role can't be completed at home anyway. So
the thing is, there's two people. The one that couldn't drive because of the traffic, the other one, that's the country lane. That's not this one. This is another one who does work quite well from home. And
Okay.
that's why in the past I guess over a period of time, she's been, you know, she gets on and does work at home, and a lot of the others don't. So it's a bit of a difficult one, because you can't go, actually, you work at home, so you can work at home, and you don't work, so you can't work. You have to, I said to her this morning, I'm going to have to look into this and have something, you know, draw a line under this, because I can't be seen to allow one thing for one and not for the other. So that's hence why I'm doing it. But I didn't know, because I know when you have an employee, they can say, they have a right to ask for flexible hours, or I don't know, whatever it is.
Flexible working.
So they do have a right. They do have a right. And I also want to put in there, Anne, I'm going to answer your question and we'll get your question in a minute. I also want to put in there, just for other employers, if an employee has worked for you for a while and they say, look, I've got roadworks, it's going to take me on a 20-mile detour to get to work for 2 weeks, can I work from home? And their job is so that they can work from home, and you as an employer are happy to let them work from home, then you can do it. We're not saying you can't do it. We are saying to Mel, we're talking specifically because we sort of know the issues that she has with these staff members. But if you did want to do that for an employee, you could. The way to do that is to agree in writing, to say, I've looked into it, sounds like it's going to be horrible. So, okay, you can work from home for this period because of this reason. And we expect you to then be back in the office from X date, you know, make it clear so that it doesn't roll on to this flexible thing where they work from home whenever they feel like it. And 2 years later, nobody really knows whether they work from home or in the office. So,
and even not working from home, you might just say, we'll temporarily change, you can start later on, or you can start earlier and miss the rush hour traffic. There's the flexibility. But yeah, a good point. Why we're saying to Mel no is because we know the background of this case.
So that means if you did a special, if you had a special arrangement for 2 weeks, it means that anyone else could ask for that as well. This is the thing.
They could, and you would then have to be reasonable. You can't give it to someone and then 3 weeks later, someone else asks you don't quite like them that much and not give it to them. And believe it or not, that is quite often how employers operate. So I like this one, I gave it to him. I didn't like that one, so I didn't. You can't do that. And go with your question.
Okay, my question, actually, it's quite interesting because where I live, Stagecoach have stopped all the buses, and there are lots of people who now can't get to work. They don't drive. The buses are their only means of getting to work. There aren't any. It doesn't affect me, but it's just, I'm throwing it out there because of what you've said. And if anybody, it's coming up in local parish council meetings when we're saying about having to supply buses. So you've got people who have jobs that have had jobs for a long time, they can't drive, they don't cycle, it's too far to walk, but there are literally no buses, and the pay that they get would not cover them getting into work. What do you do in that circumstance if they can work from home?
Again, I had this not so long ago, and as a reasonable employer, obviously the first thing is first, sit down. You're making a lot of assumptions that that employee doesn't ride a bike, she doesn't do this, she doesn't do that, they can't get in for them. Now, I suppose it varies as well with your employees, whether you've got a full-time employee, whether you've got a part-time employee, or it's a 0 hours. In the case that I had recently, it was this very scenario. There was a 0 hours employee, and the employer had, well, the club had then made the assumption, right, the bus isn't running past this area, you know, she doesn't drive, she can't come in. And I said, well, hold on there, you haven't had the conversation with her first. As she's a 0 hours employee, she can pick and choose her hours. So there may be occasions, you know, rather than sit down and have a conversation of, right, you're not going to meet the terms of your contract in being able to come to work, sit down with the employee. It might be that you ring her up and that she's got a lift to come into work. So first of all, first things first is sit and have that conversation with your employees. If they've got a permanent contract, of course, then that's when it gets a little bit more challenging, because you're expecting them to be in work. The onus is on them to come to work regardless, as harsh as that sounds. As an employer, you might want to consider putting a minibus out or something if there's a few. So you have to have a look really at your business needs as well, and how many people this affects that come to the club. That may be one of the considerations. I know where I live, on the outskirts of town, in the country areas, there are a lot of businesses that put a little minibus on to get employees into work, and they do it maybe twice a day or once a day, depending on, they've obviously looked at their business needs and looked at how they can ferry employees from a central point that they can all get to. So that might be a consideration. Obviously, if you get further down the line and that employee cannot actually physically get to work regardless, then that's a different conversation. But firstly, you need to have the conversation and you need to discuss each case on its individual merit. It sounds very basic information, but that's is as it is at the moment. You know, an employee has to make every reasonable effort to get to work. And I know that you're saying that there is no bus, but there's relatives there. You know,
yeah,
yeah.
I appreciate what you're saying, but I know that in a lot of cases there aren't from where people are, and it's going to be added to, because in Cambridge they're talking about bringing in a £5 congestion charge, and most of the people live outside Cambridge who are coming in because they can't afford to live in Cambridge. And again, that's going to affect businesses, it's going to affect people at work, and it's a really big issue.
Of course, yeah. Hopefully the council will address it. I mean, in the short term, I think, you know, in terms of what you do for your employees, get them together in an employee forum. You know, if people are on the same shift and you have one person driving and the other person doesn't drive, perhaps they could pick them up in a way they can do kind of car share and things like that.
They can have a shared taxi.
Yeah,
so that,
a shared taxi from a central point. Yeah,
and then maybe reduces
again
costs.
Though, it reduces costs, but again, the cost of taxes and things from where we are, I appreciate all sorts of things that you're saying, so I just wanted to get that clear. But in terms of quite a few people may actually literally not be able to go into work and have to give up their jobs. And if they have to do that and it's not really a fault of their own, what redress do they have? Is there any, or would it be down to the employee to say, I'm really sorry, we don't want to lose you, I'm going to give you a month or is it just, sorry?
There's no legal obligation to do that, Anne. If an employee resigns for that reason, that's not your fault that they can't get to work. That's out of your hands. So unfortunately, that's exactly what it will come down to. Some employees will leave if they can't make, you know, decisions. If somebody is trying to work, on the flip side of that, if somebody doesn't resign and they persevere trying to come in and it's causing problems where you have got staff not turning up, that's a different matter. Again, like I say, it's on an individual case by case. But if somebody resigns, you are not obligated. Of course, you're going to be sad to see that employee go, but that isn't your legal obligation to give them an enhancement to their resignation. You know, as an employer, you understand the situation, and all you can do up to that point is make every reasonable effort to support the employees. Like I say, with putting kind of looking at shifts, looking at how the business operates. It may be that, like you say, the business itself is affected by this, these buses being cancelled as well. So it might be that you have to make bigger changes in your structure and how the business is run that will also have an effect on the employees. But I think initially start by having those individual consultations with the people that you know are affected. Suggest things like the looking at who's on shift at this time. Could they kind of pick somebody up? Is there a possibility that you can put a vehicle on from work once or twice a day to pick people up for shifts? But like I say, it may mean that your business has to adjust itself along that point. It seems to be a bigger issue now coming up with a lot of the country clubs and employees that are set out of the way of the towns, because bus services and public transport is being cut dramatically in all counties at the moment. So I do appreciate the concerns you have, but as an employer, that's what you're legally obligated to do. Make every reasonable effort to ensure the employee can get to work, support them. But if the worst comes to the worst, unfortunately, you are going to lose staff.
And I think I also want to just make another point clear there. You asked about if an employee resigns, you know, do they have any redress because it's not their fault? It's also not the business's fault, unfortunately. And an employee can only really claim something against a business if the business is at fault. And the business isn't at fault. As much as the employee isn't, and we appreciate that, the business isn't either. The bit I want to make clear is, you asked about resignation. This is the ugly bit that I have to tell you. If an employee doesn't resign and they don't come to work because they can't, they will eventually be dismissed for unauthorized absence with no notice. So it is, you know, I feel like I have to make that ugly bit quite clear to you, that it wouldn't just carry on and on and on and on until an employee decided to resign, with an employer constantly trying to get them to work. And it will progress fairly quickly, I'm afraid, as well. If an employee stops coming to work and they can't come to work, it's not going to be a 6-month process before they're dismissed. It's probably going to be, you know, a few weeks of maybe trying to sort something out for them. And then if it still doesn't work, the process will start, and, you know, 4 to 6 weeks down the line, they will be terminated. And that employee will be the employer will be within their right to do that, because you have no obligation to continue to employ a person who doesn't work and can't work.
Thank you.
Okay. Right, shall we leave it there for today? We're already 5 minutes over. This has been fun. Let's do it again next week.
Thanks, Nadia. Thanks, everybody.
Thank you, everyone.
Thank you.
Bye.
Bye.